All right, thank you. I don't know how I do this, but it seems like at many of the conferences where I go to present, I oftentimes get the last session of the day. And, you know, that's always a great distinction and an honor when everybody's like, would you please hurry up so we can get out of here and go to the swimming pool or do whatever. So we'll try to move this along and let you get out to the swimming pool or out to the Red Rock or whatever it is you'd like to do for the rest of the time that you have here. And we'll try to keep it interesting and lively because this is one of those topics that can generate a lot of interest and a lot of discussion. What's the role of the public, and how do you have meaningful public engagement in these land use processes? And also really the distinction of there's different kinds of public involvement or different ways that the public should and could be involved in these land use processes. So just joining me up here, I've got Carson Eilers from the League of Cities and Towns, Wade Budge, and Gary Crane, all of whom you've already seen earlier today, so we won't take a lot of time introducing them, but I encourage them. They'll chime in as they have thoughts as we move through this presentation, and we'll try to move it along, and we encourage your questions and comments. And as I've noted already, we've had some discussion on this a little bit in some of the previous sessions. So let's move ahead and talk about this. Well, welcome to being on the Planning Commission or on the council, whatever it is that you got yourself onto. And what you'll find is that, you know, certainly if you're on the Planning Commission, you're dealing with land use issues all the time. If you're on the council, this is an interesting deal that I saw a couple of years ago when people run for the city council in most communities. They generally run because of two big issues. The first one is budget and taxes. They want to keep the taxes low or whatever. They have concerns about the fiscal situation of the community. That's one big one. The other big issue is land use. That seems to be the thing, though, the two main drivers of people as to why they may be interested to getting on that local elected body and dealing with the issues that they have to deal with there. But as people learn, when they get on that planning commission or on that council, one of the things they're going to spend a lot of time doing is talking to people, talking to the public, getting input from the public, hearing what the public has to say, and trying to deal with that and trying to figure out what it is that they should be doing with regard to what the things that they're being told about in those meetings and in those involvement sessions. I've had a lot of people say to me, you know, I mean, I get it, I understand what we need to be doing, but why can't we do this like my company where I work? You know, we have decisions to make. We get the people that we need to have make those decisions around the table, and we sit and we just make the decision. Why do we have to have all those other people coming into we don't have people coming into our board meetings and telling us what they think and what we ought to be doing. So how come we can't do that as we deal with things at our city or at our county level? Well, one of the things is, of course, land use is part of government. It's part of your community. And part of government and part of your community is public participation. And therefore, public participation is part of land use. It's a big part of what goes on, and there are very legitimate reasons for their involvement and for their for those elected officials and appointed officials to at least hear and understand what it is the people in the community think and what they want to see and what they maybe know and the information that they may have. So let's talk a little bit about why or how we got to where we are with the public involvement that we have, because we are required to do certain things with regard to land use processes that we deal with, both on the Planning Commission and on the elected body, by the elected body. So let's give you a little bit quick history. Zoning, land use regulation, really started in the early 1900s in New York and a couple of other of the bigger cities. So much interest was generated in that in the early 1920s, the U.S. Department of Commerce impaneled an advisory body or a group of people to come up with some standard, and it was called the Standard Enabling Act, or Standard Zoning Enabling Act, which became the model by which most states then authorized the use of zoning and land use regulations in their individual states. That Department of Commerce, by the way, at that time was headed by the Department of Commerce Secretary, a man named Herbert Hoover. Later became President of the United States. But he was the person who kind of started that process or got that going. And in that Standard Enabling Act, as I mentioned, most states then adopted that into their state codes, which then authorized cities and counties to enact zoning ordinances, zoning codes. Now we call them a little bit more generally, we call them land use codes, because you have zoning, you have subdivision regulations, you may have other kinds of land use codes as well. But that basic model was established in the 1920s. And there was some interesting language that was included in that Standard Enabling Act. One of the things that it called for in there was that you could set up a city or a county, and primarily this was used by cities, at least early on. They can set up their zoning code and zone property, zone their city, but that those regulations and those restrictions should not become effective until after a public hearing. So in that Standard Enabling Act, it called for a public hearing to be held prior to the enactment of those rules and of those regulations and those laws, at which time the parties of interest and citizens shall have an opportunity to be heard. There were a couple of footnotes in that Enabling Act as well. Relating to the public hearing, it said there, it's thought it's wise to require by statute that there should be a public hearing before a zoning ordinance becomes effective. There should be, as a matter of policy, many such hearings, is what it said in the act. And then it also talked about citizens. It says this permits any person to be heard, and not merely the property owners whose property interests may be adversely affected by the proposed ordinance. It is right that every citizen should be able to make his voice heard and protest against any ordinance that might be detrimental to the best interests of the city. So that was part of that original code, or that model that most states then adopted. Utah adopted the Standard Zoning Enabling Act pretty much as written, as it was proposed by the Department of Commerce Committee in 1925. And it was shortly thereafter that Salt Lake City became the first city in the state of Utah to enact a zoning code. And it was based and enabled by this code that was adopted into the state code. There was also a provision in that Enabling Act for what was called a Board of Adjustment. And this had, their purpose was to hear and decide appeals of decisions made by the administrative officials, to hear and decide special exceptions, and to authorize, upon appeal, specific cases variances. These various things, this is not the adoption of the code, of the land use. This is really more like applying it. Special exceptions has since morphed. It's evolved into what we now generally all call conditional uses. So variances we still do, and we also have appeals as well. But these are really things that fall more into what we now call the administrative role. And so this was kind of envisioned. It's not the same exactly as it was in the Standard Enabling Act, but the concept is there, that here are the administrative kind of activities that may be undertaken once you've adopted the zoning code or the zoning regulations for your community. And in that case, what the Standard Enabling Act said was that all meetings of the board shall be open to the public. And then it also says that they shall give notice of any of those actions that they may be taken to the public as well as to the parties of interest. You notice here it doesn't say anything about holding a public hearing for any of these things. It says people shall be notified of it, and that certainly the parties of interest, those that are going to be affected directly by whatever action they may be taking, they should be provided notice, but it doesn't say anything about holding a public hearing for those kinds of actions. So excuse me, this is from a law professor, Yale Law School professor, who deals with this a lot, and she wrote a paper that was in the Fordham Law Review called Over-Participation. That's an interesting title. She calls it Over-Participation, Designing Effective Land Use Public Processes. And she said the Standards Act distinction between zoning decisions, and then she calls them adjustment decisions, which are essentially administrative decisions, comports with the administrative law's distinction between legislative and she calls them adjudicative, but it's essentially, I would call them administrative proceedings, that there's a difference there in those two kinds of things. That with different rules that should generally apply. You're welcome to take a look at that. That comports with what we have been doing in our training and really how our state code is set up, and most state codes really around the country are set up, so that when you have land use actions, when you undertake land use processes in your communities, they fall into two general categories. One is a legislative type of process. The other is an administrative process. And each one of these really have different things that you need to do and different ways that you apply them. The legislative actions are the things where you're setting policy. You're deciding what the community should be like and the rules that it should operate under. So that's things like your general plan, the adoption of your zoning code, your subdivision ordinance, the zoning of property or the rezoning of property, annexations. These are handled by the Planning Commission, which makes a recommendation to the council, and the council ultimately decides these actions. These are also, as we talked about in the session last night, these are also, because it's legislative, because it's a policy type of an issue, and because of what is stated in the Utah State Constitution, these are referable. That means the citizens can go out if they disagree with what the elected officials in their community maybe have done in terms of adopting rules, policies, ordinances. They can go out and collect signatures, get it put on the ballot, and subject it to a vote. All right? Anybody, any comments on that, or should we move on? Keep going? The other part of this is the administrative actions. This is once you've adopted the rules and they are in place, and now you're receiving applications, so to speak, a land use application, a property owner or an applicant, somebody who wants to do something under the rules that you've adopted now. And now you're looking at this to decide whether this complies with your rules. If it complies, then it's entitled to approval. If it does not comply, you're entitled to turn it down until such time that it may comply with your rules. These are the standard kinds of things that you often hear about, like the issuance of a building permit, site plan review, excuse me, it's getting late. Site plan reviews, conditional use permits, subdivision plats and subdivision reviews, really any kind of land use application. These fall under those administrative rules. These are much more legal and technical, not political. Those legislative decisions are really political. The administrative decisions are legal and technical. Do they comply? Is there evidence to show that they're complying with the rules that we have adopted into our code? And if they do, then they're entitled to approval. If they do not, then we can turn them down. These are handled by what is called in our state code a land use authority. Not the Planning Commission, not the council, a land use authority. Now, under our state code, the Planning Commission could be appointed as a land use authority, and we even, under our code currently, the council itself can appoint itself as a land use authority, but it can be also individual staff. You can have like a zoning administrator, a person on your staff that will look at and review land use applications. So there's a lot of flexibility there as to just how and who that land use authority is, but they all have to operate under those rules. Anyone who disagrees with the decision of the land use authority does not take it to a vote. It goes through an appeals process. And there are rules for how that appeals works as well. You also have to appoint an appeal authority which in most communities now is becoming what are now called hearing officers or something like that. It used to be boards of adjustment, but more and more we're seeing everybody go to hearing officers, someone who has a little bit of background and training in how to deal with these kinds of issues and these matters. And so it kind of works under different rules, okay? Let's talk really quickly. Yep. Wait, let's talk really quickly about legislative actions and talk about the public participation in those legislative kind of actions. And remember, again, these are the kinds of things like your general plan adoption, the adoption of your zoning code or ordinances, rezonings of property, items like that. Not long, just shortly after that Department of Commerce committee or commission established the Standard Zoning Enabling Act, they also proposed a Standard City Planning Enabling Act. The purpose of this, and this had been discussed at about the same time, but the Zoning Enabling Act came out first. The purpose of this was to say, communities, before you adopt your zoning code, why don't you do a little planning first? And decide what it is you want your community to be and then what your zoning code ought to say. And so they established a similar kind of a standard act for how to go through the planning process. And that's where we get a lot of the rules that we have today in our state codes with how we go through that general plan, how you do your plan. This was not adopted in wholesale fashion in most states, but parts of it were. And many parts of it were, and they were modified somewhat, and that was the case in the state of Utah. And again, as you look at that code, what it says in there is that before the adoption of the plan or any part of it, amendment or extension, the commission, meaning the planning commission, shall hold at least one public hearing thereon. So this also talks about requiring a public hearing. And it talks about the purposes of that public hearing. That, of course, it gives the public the opportunity to say what they want to say about it, but that by having a hearing, and it also encourages more than one public hearing, multiple hearings, but that it's an opportunity to educate the public by giving them the opportunity to come and to listen initially to what's being proposed in the plan. They learn more about it and why it's being proposed, and gives them the opportunity to that. So it's kind of an education process. And of course, it gives the public the opportunity to have some say in what the city fathers and mothers may eventually wind up adopting as the plan for their city. Now, with relation to that, in the Utah State Code, on the legislative actions, what our Utah State Code now says is, for general plans, that the Planning Commission is required to hold one public hearing prior to recommending a general plan to the legislative body, to the council. They are required to have one public hearing. That's all that's required. The interesting thing is our state code does not require the legislative body, the council, to have a public hearing. Most do, but the state code does not require it. And then to kind of harken back to that Standard Zoning Enabling Act, our Utah State Code also requires the Planning Commission, before they make a recommendation on a land use regulation, on the zoning code, on zoning of property, on subdivision ordinance, what that is going to say and the rules it's going to establish, before they make that recommendation, they're also required to have one public hearing for that before they make that recommendation onto the council. And again, the council's not required by the state code to hold a public hearing, but most do. And it's probably a good idea. And oftentimes those are embodied in the local code. In the local city code, they'll require that that public hearing be held. All right? Carson.
I just wanted to quickly add to that. I do think we're seeing an increased appetite at the state level to have more public involvement in the community planning process. We've talked a lot about housing and land use today, so I don't need to rehash anything in House Bill 364 or 174, but what the legislature did on those bills was modify process. They asked cities to step up and do more, but they preserved the local legislative process. And another bill, House Bill 21, which ended up only having some public hearing requirements for state schools or state school district boards and then, school district boards, and I think there was almost one for the state board, and then some cleanup. But in earlier versions of that bill, I don't know if any were public, but the committee it was heard in was very close to requiring public hearings for any legislative action, and they were also very close, and never made it into a draft, to requiring public hearings on any city council action period or planning commission action period, which would have undone a lot of what we were trying to do in LUDMA. But I just wanted to bring that up. Those provisions didn't pass. I think there'll be more discussion this interim, but I think there's an increase as we kind of have some more populism or populist ideology in our legislature. We're starting to see that trend a little bit more where there's more appetite for public comment and public feedback.
And before we go on to the next section, which is administrative, I really want to emphasize that as we're thinking about this from a higher view of like where is public comment the most effective and most valuable, it's really in this arena of the legislative. Because it's in this arena of the legislative that you're gathering the whole, if you will, together and making a recommendation for a much larger area. Where you get into trouble, and we'll touch upon this later in the presentation, is when you're inviting public hearing when the law is being applied to an individual. Because that's where there's the potential for problems, because then you may have an unpopular applicant and the whole neighborhood comes against them and you end up in a different result. So, in my mind at least, and legislative, public hearing, those two should go together. That makes sense, because you're talking about applying a law across a city or across a large area of a county. And then when you get into the administrative, the arguments for public hearings, at least in the form that we often see them, really starts to disintegrate. So,
Yeah. Yeah, go ahead, Gary.
I can't be left out.
Yeah, no, please do.
This time of the day, to stay awake, I have to talk to you. So,
Me too, and I'm the one who's moderating this panel.
so, typically, what I like to do with our city council agendas is to make sure that they actually identify on the agenda which items are legislative and which ones are administrative. Pretty easy. Any ordinance is automatically legislative, right? And any issue regarding taxation is pretty much legislative. The administrative one gets a little fuzzy, but not a lot, because those are all resolutions. Resolution to approve this, resolution to approve that. The one exception to that, and this is what I wanted to point out, is kind of something in the middle, and that would be our development agreements. How many consider the development agreement to be an administrative act in your municipalities? This is a trick question, I'm sorry. I shouldn't do that.
I've only done like 2 or 3
Okay. Yeah. So,
hardly ever, never.
yeah, administrative, there's a case called the Moab case, and the Moab case was a case where, just real quickly, a certain density was approved by development agreement way back in time, and they went through the zoning process, they went through the planning commission, city council got that approved. Years later, another developer came in, wanted to add density. The city thought, well, the easiest way to do that is just by development agreement, because that's an administrative act, we can do it our own, we don't need to have the public hearings and all the trappings of a legislative act. And lo and behold, the court said no, for the purpose of, because it was referred, it was a referendum question, they said, we got to look at what it really is. And if you're changing density, that's the big thing that Wilf is talking about, the big policy question that is being addressed. And so we're gonna tell you that even though you approve this zone change or this increase in density by resolution in a development agreement, that it is legislative in nature, and you should have gone through the trappings of the legislature. So a year ago, we actually put changes into state law to actually reflect that if you do a development agreement that involves the change in density or a major change in policy, you've got to take it back through the same process that you would take it through for a legislative act. So that's maybe the one thing in land use that I can tell you is a little bit different and kind of a hybrid.
Yeah.
So
And
watch for those.
And I think part of that was driven too, Gary, by the Cottonwood Mall redevelopment proposal in Holiday City, where we had a similar deal. Well, public hearings are good and useful for consideration of those new policies and things that we just talked about and the new rules. They allow the citizens to address their local government officials directly at an appropriate time in the formulation of those policies and rules and those new ordinances. But are public hearings really representative of the community as a whole? Our state code says that prior to the recommendation of those issues, those items to the elected officials, the Planning Commission shall hold one public hearing, shall hold a public hearing. It doesn't limit them to one public hearing, but they must hold at least one public hearing before they can make that recommendation. For the kinds of things like that we're talking about, certainly your general plan updates, we'll talk about this, but even for changes to your zoning code, even rezonings of property, is a public hearing, the way we do them, is that really the best way to get public input? Is that really the best way to get a broad representation of what the public in your community thinks about those kinds of issues? There's a lot of arguments and a lot of things that say now that that's not the case. One of the big issues is when you're considering like a general plan, you're planning for the future of your city. So you're going to hear from the people that are in your community. That's great. They'll express what they think the future of the community ought to look like, but you're going to have a lot more people then coming into your community. They're not represented at all yet. And so how do you try to get that broader public viewpoint in order to at least get some idea of maybe what a broader policy consideration or what the broader view ought to be? There's a book that was written, and it's based on a body of research by some folks at Boston University. It's called Neighborhood Defenders, and they did some pretty extensive work in looking at who shows up to public hearings and what do they represent. And by and large, what they found is that those who come to those public hearings are not generally representative of the community as a whole. That they're pretty skewed in a lot of ways. 73% of the commenters were homeowners, as opposed to 46% of all the voters in the community. Only 5% were non-white, as opposed to 13% of all of the voters. And they were generally more pro-housing, and just under 15% supported new housing, as opposed to 45% of those who were minorities. So they were not necessarily really representative of the community. If that's the case, if our public hearings are really that skewed, is that the best way to get public input as we make these broader policy considerations? And the argument is maybe not. And a lot of our communities are already doing this, but maybe we ought to be doing more than just holding that one public hearing. Things like, having community open houses, or having forums or focus groups. Try to get more people involved in the discussion in different ways so that they feel like that they have some opportunity to come and express their viewpoints and their opinions. Another way is to do surveys. I'll tell you, the community where I am on the Planning Commission now, last year, we updated our general plan. Well, we were doing that during COVID. When we had these community open houses, very few people showed up. Very few people showed up. Well, we had the opportunity because the city council had funded, and they were going out to do a survey for the updating of the city's recreation plan, Parks and Recreation Plan. And we asked if we could tack on some questions with regard to the overall community plan, which was great. And they said yes. It cost a little bit more, but we did that survey, and we got some really great feedback from that. Feedback that we had not really gotten from in any other way. And so that's a really good methodology, or a way to do that. Another way, of course, is to do these kinds of things now with the technology that we have online, to put the information out there on a website or on a place where people can find it, and then allow them to submit comments that way. We did that in our planning effort as well, and we got a couple of thousand comments from people with regard to that. So that's one way to kind of broaden that involvement of the public. There's a company that does surveys for communities. It's called FlashVote. And they took a look, as part of this, they took a look at some 300 surveys that they had done for communities where there had also been a public hearing on the particular issue that they were surveying on. And what they found was this. They found that the opinions that were expressed, the viewpoints that were expressed in the public hearing varied by as much as 70% from what their results showed in a survey that they did of the community. That's a pretty big difference, and kind of goes to show that you don't necessarily get a good community representation at a public hearing. There are other things that you may need to do, and for those broader policy questions, that's maybe something else to consider. That state code requires us to have that public hearing, and they still have value. They're good. It allows the citizens to feel like that they can come and directly address their local government officials. But it may not be the best way to get the broader public viewpoint and input that you may need in the community. So, any comments from our panel here?
I'm going to put Todd Godfrey on the spot. We were talking about this just a little bit earlier, and you indicated that there was another method of gathering that public opinion. And Todd represents numerous cities in the state, and so this is an interesting approach, but it's just another concept that you might want to apply.
We're talking about using what we sort of have colloquially referred to as the UDOT method, where we'll open a comment period and allow people to provide their comments by email or online some way. It's kind of like Will talked about. And then internally, we're talking about using a process where we analyze those comments and we look at them to see in the particular decision-making process, if it happens to be administrative, whether they have actually some kind of an evidentiary basis that's significant, as opposed to those that are based more on decisions that have already been made and are in effect in the land use ordinance. And as we sift those, we create a file that indicates this is evidence that was considered, this is evidence that was given but not considered based on the nature of it. And we use that to inform our decision makers on the particular applications. That's one way to think about doing it. I'm not sure that's expedient or efficient.
Yeah.
But
But
it's
public processes oftentimes aren't very efficient. But hey, it gets you what you may need. The Yale Law School professor article that I referred to earlier, further on in that same article, she talks about and compares it to the federal environmental process, whereby when an action is proposed, they open a comment period and allow people to make comments. And then the agency takes the comments that are made, they categorize them, put them together, and then they respond in writing to those comments. That's maybe another way to encourage some input from the public, but not only to encourage the input, but then to be able to respond to that input that you receive. And in some cases, a lot of times, and any of you who've been in this arena for very long, you know at times you get comments from people that just aren't relevant to what you're looking at or have no basis for what you're looking at. And so that may allow you to say, well, we got these comments from people and that really has nothing to do with what we're looking at, and so that it's not part of the basis for what you're doing. It's a good idea. I like the idea of doing it, but let me tell you what, it's staff intensive. It takes some time to be able to go through those comments and then respond to them in writing. So that's maybe the downside to that.
I think that anybody that's been on the planning commission or on the city council would argue that the majority of the comments you get have absolutely nothing to do or are just clamor and emotion driven. But you said why is the opportunity for the public to feel heard? Why is if it's not based in any kind of scientific information or it's not giving new data to the decision maker or policy makers, why is it even considered?
Well, I look at what I showed you there in that Standard Planning Enabling Act, where it talked about that the purpose of having a public hearing, one of the purposes, is to help educate the public. And certainly at that time in the 1920s when this was adopted, they didn't have as many forums available to them, I think, as we have now to get information out to the public. so that by having them come to a meeting and then having them sit through a presentation and saying, this is what we're doing and why we're doing it, and then the public could go, oh, okay, well, I didn't understand that. Now we have other ways of doing that. You know, those open houses, certainly the online, much more so than we used to have in the past, or never had in the past. But so there is still a public information part of that. But, you know, I mean, part of it too is it allows the public to feel like that they're getting a chance to address their officials directly. And it maybe helps increase some of the buy-in, especially maybe as they get those officials to respond back to the public and say, well, think about this. So, Brent?
I'm pretty sure that if you don't have public hearings and let people say everything they want to, children will die.
I think another aspect, good one. I think another aspect too is just protecting and preserving public trust in the process, being transparent and open with your public. I think we've done some survey work at the League trying to see how people feel about different levels of government, how much they trust different levels of government. And what we found time and time again is that people trust their municipal leaders most to plan for their community much more than state leaders, much more than federal leaders, obviously. But I think that comes down to feeling like you have a voice in the process. Even if you're in the minority on a legislative decision, having the ability to redress grievances and having the ability to feel heard, I think still matters and makes you feel like you've had a chance to participate in democracy. I think one of the challenges we're seeing at the national level is like people don't vote because they don't feel like their voice matters. I mean, I know in Utah, for example, or any state that's not purple, your vote probably statistically doesn't really matter that much, and I think people feel disenfranchised and don't participate. So obviously there's different spaces, whether it's legislative or administrative, but I think that element of trust is really, really important for municipal leaders to bear in mind.
Okay, let's move on to the really interesting one now, which is administrative decisions. All right, now we're talking about a whole different ballgame. And maybe we need to look at this a little differently. Again, just to remind you of what the administrative actions are. This is where someone's asking to do something. They're applying to do something under the rules and regulations that you've now put in place through the legislative process. You've adopted those codes and ordinances. You've put the zoning in place. And now the rules are there, and someone wants to come in and do something under those rules. Now, how should that work? Under Utah Code, for administrative actions, there is no public hearing required. None is required by Utah State Code. Now, we talked a little bit earlier today about Senate Bill 174 and the subdivision review process, and there is a clause in there now that says that in reviewing a preliminary plat, it may be done in a public meeting, and you may hold one public hearing on it. You know, I and others did not like the fact that we were going to start saying that you can hold a public hearing for an administrative action because of some of the reasons we're going to talk about here as we move on a little bit further. But as Carson just indicated, there's been some real pushback amongst the constituency and to some legislators saying the public needs to be more involved in some of these processes. And so I think that really pushed that. It also pushed the change that was made to that referendum bill that we talked about a little bit earlier because of that push to say the public needs to be more involved in these kinds of things, and we shouldn't be precluding that. There's a basis for that, certainly on the legislative side. I just saw in the paper this morning, interestingly, that Governor Cox sent a letter to the legislature saying, you guys need to have more public involvement before you pass these bills, right? So, you know, and that's legislative action. So that may be appropriate there. But let's talk about the administrative side of things. Again, under that state enabling zoning, that state standard enabling zoning act, it said all meetings of the board are open to the public and that they shall give public notice thereof, but it says nothing about them having to have a public hearing. And as I mentioned, it also said nothing about that in the state code. about having a public hearing. It doesn't preclude public hearings from being held on administrative actions, but it doesn't require it either. Now, I'll tell you this, you know, in my 40 years of being a planner, early on in my career, there were always public hearings held for what are now considered administrative actions, conditional use permits, subdivision plats, site plan reviews. It seemed like every one of them, as part of the process, when it went to the Planning Commission for review, that there was also a public hearing held with regard to that. And that was oftentimes required by the local code or the local ordinance. Why? I think it was tradition more than anything else. I think it was just people felt like that was what government ought to be doing. Government ought to be open and accessible to the public. And so that kind of went forward. But as we've gotten a better understanding of the difference in these kinds of processes, that's kind of been fading away. And there's a little bit of a different understanding going forward on it now. The reason for that, what's the nature of a public hearing? What happens at public hearings? Some of you have already talked about this. You know, what do the public come and say? Brent has already said that people come and tell you that children are going to die. And crime and lower property values and more traffic, right? You get that at every public hearing, you know?
And don't forget the bullseye on the bingo card, because that's what we're talking about, right? We all have a bingo card with children will die, property values. The bullseye is my realtor told me something different. And so,
Right.
yeah. Yeah.
Now, I don't want to be disrespectful of the public and their role in this. But really, when people come to a public hearing, what they really are expecting to do is give you their opinion. They want to tell you what they think. They very rarely come with any actual information, anything based in fact. They'll tell you, you know, things like traffic's going to increase on this road to the point that it's just not going to be usable anymore. Well, have you got an engineering study to back that up? Or is that just your opinion? You know, and so it's really, when you're in the legislative arena, it's a little bit more loosey-goosey, squishy, you know, allow that to go. But when you're in the administrative, it gets to be a different ball game, and we need to be considerate of that. We have a question up here. Comment.
New to city council, following on the heels of a mayor that just had the best comeback. Whenever he gets somebody that was really agitated and really fired up about something, he says, I am so glad you are passionate about this subject. And we are looking to form a committee and need somebody to head it up. Would you volunteer? And they go out the other door.
That's great.
Yeah. So is a public hearing really the proper vehicle to get any kind of input that you may be getting, or maybe you need to get, or do you even need to get when you're doing an administrative item? And if you who were here last night, you heard the legal decisions and all of the standards, substantial evidence. You have to have evidence for the decision that you're making, evidence, not opinion, you know, and can you get that? Sometimes the public will provide that. Sometimes that will happen. You know, I can think of situations where when it's really a big issue and like you're having a development of some kind proposed, and of course that developer then may be required to do a traffic study, and the citizens in the neighborhood around there, you know, they're really opposed to it, so they go hire their own traffic engineer, right? And that traffic engineer says, oh yeah, it's going to cause this road to fail. Well, then the body is left to decide, okay, whose expert opinion here do we believe? But at least now there's a basis. There's some factual basis for this. Not just people expressing their opinion that it's going to increase traffic and make the road fail. You know, so they have some basis for that. But honestly, that does not happen very often in those kinds of arenas. It will on some of the bigger issues. So if that's the case, you know, this is from a University of North Carolina School of Government professor, where he talks about the important difference. He calls them evidentiary zoning hearings. This is where you're considering really an administrative type of action, and you need evidence. You need to gather evidence and information, and he talks about that being different from the legislative. I won't spend a lot of time on this. It's cited in the paper that you all have, and you're welcome to go back and read that. But he just talks about there's a substantial difference here. You know, you're looking for facts and information when you're doing any kind of fact finding on an administrative issue. On the legislative, it's a whole different ball of wax, so it's something to be considered. He goes on and says that here, the purpose of an evidentiary hearing is to carefully gather relevant facts to aid in the decision-making. So you should have restrictions. This is what they do in the state of North Carolina. You should have restrictions on what can be heard and how it can be heard and applied to those hearings. It is inappropriate in an evidentiary hearing to consider non-expert personal opinions or hearsay testimony. All right? All right. We also have, we have direct guidance from our own courts here in the state of Utah. We've got a couple of decisions that were made that say basically the opposition of neighbors is not one of the considerations to be taken into the account when determining whether to issue a development permit. The consent of neighboring landowners may not be made a criterion for the issuance or denial of a conditional use permit, which is an administrative action. So we have some direct guidance right here from our own courts. Begs the question, should we even be having any kind of public hearings for administrative items? We just got a bill that's passed that says we can have one for subdivision plats, but should we? Should we be doing that for subdivision plats, for conditional use permits, for any administrative action? Should that be the case? Now, as we just talked about as well, and Carson pointed out, we're getting pushback, and we've got legislators who are feeling that pushback. And they seem to be leaning towards maybe looking at requiring more public involvement, even in administrative decisions. Maybe what we need to do is we need to suggest an alternative. Gary Crane and I talked about this a little while ago, and if we feel like that we need to have hearings for administrative items, then maybe they shouldn't be public hearings. Maybe we should call them something else. Maybe we should call them administrative hearings. In North Carolina, they call them evidentiary hearings. That sounds really legal and, gives everybody the willies, I think, when they feel like they're getting in front of a legal action. But what if we at the local level say, all right, because there is no restriction that you have to have a hearing on an administrative item in our state code. So at the local level, if you want to have a hearing for something, why not create a new kind of a hearing and call it an administrative hearing? And have some rules in place, as the University of North Carolina professor suggested. It's got to deal with issues and facts rather than opinion. And what that will help too is it helps the public to understand the difference, or hopefully it will. But that's one of the things that maybe we, over time, as we build that up, that people begin to understand a little bit better. What's the difference? In this case, it doesn't really pay to come in and express your opinion, because that's not going to matter. What you need to present is information and facts in order to help that body there to make the decision on whether that land use application should be approved or not. Comments, gentlemen? I would appreciate your jumping in here.
So I blame the mayor or the chair for a hearing that goes out of control, or for things that mess up during the course of a meeting. The reason I say that is it's my fault probably as the city attorney, or the city officials that are actually doing the educating really need to educate a council and mayor as to what is an administrative hearing and what are the criteria. The sweetest words that I ever hear during the course of a city council meeting from the public are, I know you can't make any other decision but to approve this if it meets the ordinance, but here's what I'm going to say. And those are sweet words, because what it says is not only does the mayor and the council understand what's going on, and somebody has informed the public of what kind of hearing this is, it's an administrative hearing, but it also says that the citizens understand that no matter what they say during the course of that hearing, unless it has something directly to do with the facts as they relate to the ordinance, that the council's bound to have to do this. It gives them an out. It gives them a safe place if they understand upfront what the rules are. I don't think we're going to get away with taking out all public hearings based on what Carson said and based on what we heard in the committee meetings.
Yeah.
They were nuts in the committee meetings. They
In the public
truly-
hearings, Gary?
They were all public hearings, yeah.
Yes.
And I love the legislature. They make all the rules for us, but their rules are totally different. I've seen them say, we'll open the hearing, you can talk for 5 minutes, you talk for 1 minute. And that whole thing goes that direction. But seriously, I think it's an education process. We're gonna have to learn to educate our councils and our mayor. And up front, there ought to be some type of soliloquy. I thought this year I suggested that we put in the state statute a requirement that at the beginning of every administrative hearing, that whoever is, whether it be the planning commission or the mayor, that they make a statement. This is an administrative hearing. This is a hearing where the city council must apply the facts to a city ordinance. If the applicant meets all the terms of the city ordinance, the city council must approve this application. And then proceed with the meeting, let them talk, because that's the kind of thing that needs to be understood by the public as well as by the city council. And so, it wouldn't hurt to do that type of thing is all I'm saying. So you're not gonna get rid of them.
Go ahead, Todd.
Yeah.
So I want to start out by saying I'll never vote in a city council or planning commission meeting. That's not my role. I'm totally on board with what is being said here. About 6 years ago, I had a client whose planning commission chair was an attorney, a planner. He writes code for a living. He's a remarkably respected guy, very talented. And we prepared for him for planning commission meetings a statement he would give at the start of every administrative hearing. And we bunched our hearings on our agenda so the administrative stuff was first, the legislative stuff was second, or vice versa. We also put a little piece of paper outside in the hallway where people signed up where they were going to give public comment on an item that had the exact same statement on it. He gave up giving that statement about 6 months in. And he said to me, this is useless. Nobody listens. Nobody understands it. They read it and they don't care. They come to say what they're going to say and they say what they're going to say. And he said, we would be better off just accepting the fact that if we have no public hearings, what we're doing is effectively imposing term limits on our council members without saying the same thing and doing that. So we have a big gap to bridge, and it's just, realistically, it just is what it is. Our practice over the course of literally 100 years now has created an expectation, and it's going to take a long time to reverse it. I'm in favor of starting, but it's going to be difficult, and I don't think we should have any illusions about we can get our planning commission meetings from 9 o'clock down to 7:30. I don't think that's going to happen that way.
Good point, thank you.
Thanks for the compliment too, Todd. That was me. But I agree. It's going to take a while to turn that tide back, and there's no way you're ever going to control what's said at one of these meetings if you invite that type of meeting by putting it in the code that you're going to hold that public input period. But the more we can educate, the better off we are. So.
And I think it's important to educate the public about the different, talk about it as different roles, because even when I talk to legislators who have run bills modifying the Land Use and Development Management Act, many still don't understand the difference between a legislative act and an administrative act, just because as a legislator you don't think you're only thinking as a legislator. I think your residents feel the same way. They just see you as a city council member or a mayor, and they expect you to be using your policy discretion wherever you can. I think that's the way, when we talk about civics in high school and in colleges, that's the way we teach it, is you're an elected official, you use your policy discretion, and we don't ever talk about the nuances. And I think, we need to start talking about that differently.
But I think we do the service to the public when we emphasize to them that they should really think of participating at the legislative and general plan level, meaning the local, when you're dealing with the zoning ordinance or you're dealing with a general plan, because that's where their input's the most valuable. I think that if you have a legislator, for instance, Carson, to your example, who says, I want a public hearing at every government action, we're like, okay, how about when you have your planning clearance for your building permit? You want a public hearing for that? You know, you may not want to have the public then come and opine as to some aspect of your home and sit there and listen through that. So my point is that the administrative is certainly on another side of the scale. I agree there's a reality that we have to deal with, as Todd has indicated, but we shouldn't completely yield the land. I mean, I like the idea of really emphasizing legislative versus administrative. You get too much into the area where comments can get personal as to a particular applicant if it's administrative.
So last night I talked a little bit about this in saying that one of the reasons why it's really important to help the public understand the difference is because when you have that public hearing for an administrative action, the public comes in and says what they're going to say, and then you as a body, planning commission most likely, but sometimes the council say, okay, thanks for all your public comment. Now let's take a motion to approve this. And the public is sitting there going, we just told them all the reasons why we didn't want this to be approved. They're not even listening to us. Those dirty buggers, they already had their mind made up before they even started this. Happens all the time, oftentimes because the public does not understand. And so that's why it's important to try to do that. But, you know, you may not completely succeed. Let me just show you a little bit of what can happen. This is a bill that's before the Montana State Legislature right now. It's called the Montana Land Use Planning Act. In that bill, on legislative items, what it says is you have to do broader public participation, all the stuff we just talked about. And it actually even requires that a local governing body shall develop a plan for the kind of public involvement they're going to have for these legislative actions. And they give a whole list of menu items, a menu of things, which are all the things we just talked about. That's what they have to do if this bill passes for legislative items. For administrative items, what it says that if all of the impacts were addressed during that legislative process, then when an administrative item comes to them, the application must be approved or denied by the planning administrator and is not subject to any further public review or comment. This is proposed in the Montana bill. This bill passed by a 42-6 vote in the Montana State Senate a couple of weeks ago. It's now up for consideration in the Montana House. It looks like it's going to go. It's got broad public support. Folks, it can be done. It just takes some work and some time. So we're about out of time. We probably don't have a lot of time for questions or comments, but we will take what we got. Brent.
I just wanted to say, and this is partially in response to what Todd said, you know, land use debates, NIMBYism, all this kind of stuff is as old as civilization itself.
Yeah.
We have never figured out in this world how to get rid of NIMBYs or anything, or this public comment issue is the same. What makes me sad is the idea that someone would give up trying, right? Because what we're talking about here is the right way to handle it, right? And just eventually just throwing your hands up and giving up and let it go, that is, I think, is where we finally lost.
Yeah, well said.
I served as the city manager for Nibley a couple of years ago, and one thing that we did, our mayor actually proposed this because we had we were a very fast-growing city, they still are, and one of the things the mayor proposed was to put some space between the hearing and the decision. And his proposal was that we have a public hearing at one meeting, but never make the decision at that meeting, and always wait at least until the next meeting, which was usually 2 weeks later, before a decision was made, which allowed all of the tempers to cool down. The council or planning commission wasn't feeling the pressure of all of those people staring at them saying, I just told you why you should not make this decision. Don't you dare make this decision. 2 weeks later, most of those people didn't even show up at the meeting. It allowed things to calm down, people to think about it, and I think it worked really well.
That's a good point. All right.
Thanks.
Sorry, I made her bring the mic to me. I didn't go stand in line in the back. So I think it's important to realize or remember we're in the business of public trust as well. I had this conversation with my new mayor about the concerns of the public, and I told him, we're here for services, and I don't have an application from someone that's at home on the couch mad at the TV or watching TV just mad, right? This is the outlet for the members of the community that don't have an application on file. They're not spending their money. They're not risking anything, that, if that makes sense. And so I think just that mindset. But I do think we need to get more value out of the public hearing if it can inform public policy, or if it can inform future actions instead of making it about the current applicant, right? If we can get somewhere out of those comments, what is it that you don't like that we just applied to this application? Is it the street width? Is it the sidewalk? Is it the setbacks? Is it the fencing? You know what I'm saying? And maybe if there's some way to incorporate that into the public hearing, does your comment have any, bearing on future, to engage them on a different level and something that could be considered into the future, but kind of take the pressure off of that current application on file unless we miss something.
Great, appreciate that. All right, Craig, you want to close the conference?
Sure. Have a blessed Easter weekend.